Finally, I want to give you one more data point to help you understand the mindset and intent of the founders and how this country was originally supposed to work, and that involves our right to the trial by jury. Here are the main chunks of the Constitution and the Bill of Rights, which establish the jury system and outline its conditions. Article 3 of the U.S. Constitution.
Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Section 2. The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed.
The Fifth Amendment.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use without just compensation.
The Sixth Amendment.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
The Seventh Amendment.
In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
The concept of the jury being of your peers is even older than the Constitution and comes from English common law and the Magna Carta, but we'll discuss this shortly. But with all that in mind, stop and think about that for a bit. What's the point of a trial by jury? Why even have one? Why not only have judges? Judges would certainly understand the law better than the average untrained citizen. Or, if there's some benefit to having a group of people make the decision, then why not have the jury composed of seasoned lawyers? Why do they drag normal people out of their daily routine and have them waste their time sitting on a jury? What's the point? It's simple. The fundamental philosophical purpose of a trial by jury is that the government is asking the people for permission to enforce a given law against a given person in a given situation. A jury serves as representatives for the people to act on behalf of the people in order to give permission to the government to enforce that law and punish that person. The jury is the conscience of the law. Remember that bit about the government getting its power from the consent of the governed? And how we, the people, have the ultimate authority over the government? Well, the trial by jury is how we, the people, give that consent. The prosecutor doesn't present their case to the judge. They present their case to the jury. Why? Because it is the jury that actually convicts the person. The prosecutor presents their accusation and their evidence to support it, and then the jury is the one who decides whether or not to convict the person. We, the people, are the ones who convict them. A jury of your peers. In other words, your peers are the ones who convict you, not the government. The concept of juries, in various forms, has roots in ancient Rome, ancient Greece, ancient Germanic tribal justice, Anglo-Saxon England, and English common law. But in terms of the trial by jury in its modern form, which would ultimately be adopted by the American Founding Fathers, perhaps the most direct influence was the Magna Carta in 1215 in England, when the barons demanded limitations of the king's authority and the establishment of certain laws and protections superior to the crown. The name Magna Carta is short for Magna Carta Libertatum, which is Latin for the Great Charter of Liberties.
No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. Clause 39 of the Magna Carta Libertatum, 1215.
Another might be the Declaration of Rights, also known as the English Bill of Rights, issued by the English Parliament in 1689 after the Revolution, which overthrew King James II, and installed William of Orange and his wife Mary II. It first outlined the abuses of the previous king, and then asserted a list of rights which would be honored under the new reign. In it, one of the listed abuses was the corruption of the jury trial, and one of the asserted rights was a renewal of the guarantee of jury trials.
Whereas the late King James II, by the assistance of various evil counsellors, judges, and ministers employed by him, did endeavour to subvert and extirpate the Protestant religion and the laws and liberties of this kingdom. And whereas of late years partial, corrupt, and unqualified persons have been returned and served on juries in trials, and particularly various jurors in trials for high treason, which were not freeholders, the said lords, spiritual and temporal and commons, do in the first place, as their ancestors in like case have usually done, for the vindicating and asserting their ancient rights and liberties declare, that jurors ought to be duly impanelled and returned, and jurors which pass upon men in trials for high treason ought to be freeholders. English Bill of Rights, 1689.
The difficult and complicated philosophical perspective on the balance between unifying government power and the independent liberty of the people has been evolving for thousands of years. The American experiment was an attempt to culminate that evolving philosophical perspective of the Enlightenment in what they believed was the next step, fundamentally inverting the power structure of the government and establishing the people themselves as the originating sovereign power, and reframing government as a utilitarian tool for the benefit of the people, but still restraining that government through explicit laws and articulated rights, as opposed to the true democracy of ancient Greece. This is explicitly outlined in the Declaration of Independence.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government and to provide new guards for their future security. The United States Declaration of Independence.
In 1789, Tench Coxe wrote a piece for the Philadelphia Federal Gazette under the pseudonym A Pennsylvanian, in which he reassured his readers that this sentiment had been upheld within the design and intent of the Constitution and its amendments.
The manifestation of good faith, which this motion carries, is matter of no dishonorable reflection on the friends of the new Constitution, and the ingenuousness and moderation discovered by the gentlemen of the House who have desired amendments excites feelings of the most comfortable nature. The people must rejoice to find that their rulers, of however diversified opinions, are equally anxious for their country's happiness. The first article, pursuing the republican spirit with which the Convention of 1787 designed to animate every part of the Constitution, declares in the most unequivocal terms that all power is the exclusive right of the people, that from them alone, therefore, it can be justly derived that it is granted by them for the promotion of their own benefit, that it can only be exercised to increase and preserve their happiness, that whenever this frame of government shall prove unequal to the attainment or destructive of that essential object, the public good, it must be reformed or altered, and that it can be at any time reformed and altered by an indubitable, unalienable, and indefeasible right, which always remains in the people. This is indeed the creed of liberty to which every American will give his unqualified assent. Remarks on the first part of the amendments to the Federal Constitution by Tench Coxe under the pseudonym A Pennsylvanian, as reprinted in the Massachusetts Sentinel.
13 years after the United States proclaimed its independence, at the start of their own revolution, the French would be inspired by the American Declaration of Independence and the spirit of the Enlightenment, and draft their own Declaration of the Rights of Man and of the Citizen in 1789, which echoed a similar perspective.
The representatives of the French people formed into a national assembly, considering ignorance, forgetfulness, or contempt of the rights of man to be the only causes of public misfortunes and the corruption of governments, have resolved to set forth, in a solemn declaration, the natural, unalienable, and sacred rights of man, to the end that this declaration, constantly present to all members of the body politic, may remind them unceasingly of their rights and their duties. Article 1st. Men are born and remain free and equal in rights. Social distinctions may be based only on considerations of the common good. Article 2. The aim of every political association is the preservation of the natural and imprescriptible rights of man. These rights are liberty, property, safety, and resistance to oppression. Article 16. Any society in which no provision is made for guaranteeing rights or for the separation of powers has no constitution. The French Declaration of the Rights of Man and of the Citizen.
Note: obviously, the original version of this was written in French, so I have provided two sources with independent translations, if you wish to compare. The quote above is taken from Élysée, an official French government website, which describes itself as the official website of the President of France, on the English version of its homepage. I recommend reading the whole thing. You can also see similarities to the U.S. Bill of Rights, although from an interestingly different perspective, as well as a difference in which aspects of liberty they chose to emphasize. I particularly like Articles 4, 5, and 9. I'm also curious what effects Articles 10 and 11 have had or will have on social media. Interestingly,
the first draft was penned by the Marquis de Lafayette with the help of Thomas Jefferson. This draft of the Declaration of the Rights of Man and of the Citizen was written and presented to the French National Assembly on July 11th, 1789, just 3 days prior to the storming of the Bastille on July 14th, 1789, where Lafayette himself helped to save Louis XVI as well as Marie Antoinette as head of the National Guard of Paris. The final version of the Declaration was written by Emmanuel Joseph Sieyès and the Comte de Mirabeau. It was incorporated into the French Constitution in 1791. The Declaration of the Rights of Man and of the Citizen helped to form the foundation of the French Revolution in hopes of ending the monarchy and establishing a democracy in France. Lafayette's draft of the Declaration of the Rights of Man and of the Citizen, American Battlefield Trust.
The Declaration of Independence wasn't their only inspiration, but also, importantly, their goal was not to merely clone other countries' approaches, but rather to found their perspective on the fundamental thread of Enlightenment philosophy from which all had sprouted.
On 26 August 1789, the French National Constituent Assembly issued the Déclaration des droits de l'homme et du citoyen, Declaration of the Rights of Man and the Citizen, which defined individual and collective rights at the time of the French Revolution. Some delegates at the Assembly had expressed their admiration for Magna Carta and other constitutional documents, such as the United States Declaration of Independence, but ultimately the Declaration rejected appeals to ancient charters of liberties, based on the principle that the rights of man were natural, universal, and inalienable. The Declaration of the Rights of Man and of the Citizen, British Library.
A common thread through these perspectives is the move away from the idea of a divinely ordained king and towards the egalitarian idea that people are just people, and that social and political class are fabricated tools for constructing a functional system of society. This does not mean that all such constructs have no meaning, nor that they are not necessary. Spoken language itself is a fabricated construct, and yet it is vital to life. Written language is also a fabricated construct. The symbols representing sounds are arbitrary, but each holds tremendous historical meaning and tells the story of its ancient evolutionary history and the cultures which shaped it. And this is precisely the difficulty. As I mentioned earlier, this philosophy has been evolving for thousands of years, exploring these constructs, discovering their consequences, and trying to figure out which ones are good and which ones are dangerous. If you go back far enough, kings were thought to literally be gods themselves, or to become gods after they died. Over time, kings have been humanized and brought closer to the common man, and governments have been restrained and systematized through laws and frameworks. At the time of the American Revolution, the Founding Fathers believed that the next step was to invert the structure of government. Rather than the government being the source from which the people gained their identity and freedoms, instead, the perspective was reframed into a naturalistic view in which the people themselves were the root foundation which predated all forms of government and existed in a natural state of freedom. And governments were a tool which the people created to organize their cooperation amongst each other. Rather than the government being the supreme sovereign and the people existing to serve the government, instead, the people are the supreme sovereign, and the government exists to serve them. Part of this inverted perspective was the reframing of the origin of rights. Instead of viewing rights as things which governments grant their citizens, rights were viewed as being inherent to our nature, and governments can only either protect them or infringe upon them. They also understood that governments have a tendency to become corrupt over time and seek their own growth and magnification of power. Thus, they designed the structure of the government to contain within it checks and balances in order to restrain its power. But it is important to understand that all of these protections were intentionally designed to make the government weaker, less unified, and less efficient. The other key protection was to establish the continuous intervention of the people into the core function of the government in every branch to ensure that the government was forever dependent upon the people for its continued function and power. One of the primary ways in which this was accomplished was through the trial by jury, and this sentiment is consistent all the way up to the modern day.
Our commitment to Apprendi in this context reflects not just respect for long-standing precedent, but the need to give intelligible content to the right of jury trial. That right is no mere procedural formality, but a fundamental reservation of power in our constitutional structure. Just as suffrage ensures the people's ultimate control in the legislative and executive branches, jury trial is meant to ensure their control in the judiciary. Blakely v. Washington, 2004, U.S. Supreme Court.
It's not just about whether or not the prosecutor can prove that a person broke a law. It's also about whether or not that law is a bad law, or whether they're trying to enforce a good law in unreasonable circumstances. The jury has the right to reject bad laws and overzealous prosecutors, and vote not guilty, regardless of whether the person actually did it.
In the early history of the American colonies and for a time after the Revolution, juries were nearly always recognized as having the power to judge both law and fact. This is exemplified in the early Supreme Court case of Georgia versus Brailsford, in which Chief Justice Jay declared, "For as, on the one hand, it is presumed that juries are the best judges of facts, it is, on the other hand, presumable that the court are the best judges of law. But still, both objects are lawfully within your power of decision." In criminal cases, juries remained the judges of both law and fact for approximately 50 years after the Revolution. However, the judges in America, just as in England after the Revolution of 1688, gradually asserted themselves increasingly through their instructions on the law. We recognize, as appellants urge, the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge and contrary to the evidence. This is a power that must exist as long as we adhere to the general verdict in criminal cases, for the courts cannot search the minds of the jurors to find the basis upon which they judge. If the jury feels that the law under which the defendant is accused is unjust, or that exigent circumstances justified the actions of the accused, or for any reason which appeals to their logic or passion, the jury has the power to acquit, and the courts must abide by that decision. United States versus Moylan, 1969. United States Court of Appeals, Fourth Circuit.
We'll look at a longer quote from that Brailsford case later in this article, but for now, let's finish setting up the premise. This design of erring on the side of protecting the people's freedom at the cost of making the government weaker is why even if a person is convicted in court, they can appeal the judgment to a higher court multiple times, all the way up to the Supreme Court, providing multiple opportunities to secure their innocence. However, if a person is found innocent, the government cannot appeal to a higher court to try again to convict them. This is forbidden by the Double Jeopardy Clause of the Fifth Amendment, which forbids the government from trying the same person twice for the same accusation.
Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. The Fifth Amendment to the Constitution.
Tench Coxe emphasizes this aspect in his previously mentioned article.
The humane and wholesome maxim of the common law, which protects even the guilty from double punishment, is recognized in another clause.
While double jeopardy existed in some cultures in various forms, as far back as ancient Rome, these instances had limitations and were not as protective as the modern incarnation, such as being limited to only certain types of crimes, only certain types of verdicts, the degree or type of punishment at risk, allowing supersedence by a more severe charge for the same act, allowing re-prosecution within a certain time limit after the previous trial, or simply lacking in authority such that they were completely ignored by those in power when it suited them. In the U.S. Constitution, this principle was standardized, universalized, and granted the supreme authority of the Constitution, the highest law in the land. Note: just to be clear, the previous trial has to actually be resolved for double jeopardy to apply. If it ends in a mistrial, such as from a hung jury, then it wasn't actually resolved, and the government has the option of starting a new trial. There's also something called the separate sovereigns doctrine, aka dual sovereigns, when referring to state versus federal, which was recently upheld by the Supreme Court in a 6-3 decision in 2022, is an interpretation of double jeopardy, which allows different governments to prosecute the same crime. So, if a state government tries you for a crime, regardless of whether you were found guilty or innocent, the federal government can still try you again for the same crime. I'll leave it to you to decide if you think that's fair or not. Erring on the side of making the government weaker is also why the jury must be unanimous in criminal cases, so that all it takes is a single person on the jury to protect you from the power of the entire government. Think about that. Even if the whole of both houses of Congress passes a law unanimously, and the president confirms it, and the police enforce it, and the district attorney prosecutes it, and the judge upholds it and commits the charges to trial, even if every speck of every branch of the entire government is unanimously brought to bear against someone, all it takes is a single juror to say no, to hang the jury, and the entire government is made impotent. One juror is more powerful than the entire government. The best that the government can do is declare a mistrial and try again with a new jury.
It is better that 10 guilty persons escape than that one innocent suffer. William Blackstone in Commentaries on the Laws of England, 1765.
Later, in 1785, Benjamin Franklin would echo this sentiment, but even further exaggerated.
That it is better 100 guilty persons should escape than that one innocent person should suffer is a maxim that has been long and generally approved. Benjamin Franklin in a letter to Benjamin Vaughan on March 14, 1785.
Jury independence. Erring on the side of making the government weaker is also why, in the United States, jurors are immune to repercussions for their verdicts, so you can act against the will of a corrupt government. But it is important to understand that this was not the case in England before the American Revolution, nor even well after it. Under English law at the time, hung juries could be put in jail overnight, without food, water, nor heat, every night until they reached a verdict. This continued to be the case until as late as 1870, when such imprisoned juries were allowed food and heat, but only at their own expense. Juries could also be fined under contempt charges if they returned a verdict which the court disagreed with, resulting in prison time until the fine was paid. Judges could order the jury to give a certain verdict, and often repeatedly sent the jury back to deliberate until they gave the verdict the judge wanted, and judges even outright threatened the juries to gain their compliance. Some cite the trial of William Penn and William Meade, and the resulting trial of one of their jurors in Bushell's case as the turning point for such practices. But such events did not have quite the transformative effect in England at the time. Although they did serve as key influences of the American philosophy on jury trials, particularly because William Penn would later come to America and found the state of Pennsylvania. This is why in U.S. law, barring extenuating circumstances, such as jury intimidation or tampering, etc., courts are obligated to accept a jury's verdict, and jury members are immune to consequences for their verdicts. Mob rule. You might object that by making the jury above the law, this is just mob rule, the same thing that I condemned in a true democracy. However, this is not the case, because in the same way that such a trial by jury weakens the power of the government, the very same mechanism weakens the power of mob rule by the people. Because, while the jury does have supreme judgment capacity within a jury trial, they only have it there, and only the government, i.e. the law, can bring such a case against someone. So, in other words, in the same way that the government is made weaker by having its constituent parts pitted against each other, such that they must agree in order to wield their powers, in the same way, the mob rule of the people is made weaker in that it can only have its way if the government, i.e., the law, agrees with the mob's decision. The people cannot, by themselves, initiate a criminal prosecution. Only the legislative branch of the government can do that. So the people are free to hate someone, But unless the government cooperates with them to enforce a law against them, the people are impotent to harm someone, unlike in a true democracy, wherein the people can demand anything for any reason, and they can initiate such an action on their own at any time. So while it is true that a jury trial does in fact restore a large degree of autonomous power to the people, that power is still regulated by the law, through the government agents within the courts, and also in the executive branch. At any time before conviction, the judge can throw out the case, or the prosecutor can drop the charges, but the jury can only convict them if the court upholds the case to the very end. And even if the court cooperates with the mob to convict someone, it still requires the executive branch to enforce their punishment. And even then, that person may still appeal their conviction to higher and higher courts for multiple chances of having their conviction overturned. So, in order for the mob to harm someone, it would require an existing law to prosecute, as well as the unanimous cooperation of the entire jury, two branches of the government, and every level of the appeals courts. It's certainly possible. I'm not going to say it's perfect, but it's hardly as simple as mob rule. Also, there are indeed some checks and balances placed on jury verdicts as well, but they too, as always, err on the side of individual liberty and making the government weaker. There actually are a few instances in which a judge can overrule or ignore the jury's verdict. This used to be called either directed verdict, when done before the jury reaches a verdict, or judgment notwithstanding the verdict, when done after the jury reaches a verdict. But these have mostly been replaced by judgment as a matter of law, for civil cases, and motion for a judgment of acquittal, for criminal cases. In simple terms, a civil case is an arbitration of liability between two people, or legal persons like a corporation, or even a portion of the government, as opposed to a criminal case, which is a determination of a person's guilt before the law. In a civil case, the judge can overrule the jury's verdict if it would violate the laws which protect the person who lost the case. For example, if you ran your car over my bicycle, and I sued you for damages, and for some reason, the jury decided to award me $1 billion. The judge could overrule that verdict for being excessive and lessen the value of the damages. Another instance in civil cases would be if the evidence is overwhelming or non-existent. The judge can rule without the need for the jury to reach a verdict at all. But such rulings can also be appealed if the losing party believes it to be unfair or unwarranted. In criminal cases, this is also possible, and the judge can either bypass the jury and rule without them, or overrule the jury's verdict, but only if done in favor of the defendant. In other words, the judge can force a verdict in favor of the person and acquit them as not guilty, but cannot force a verdict in favor of the government and condemn the person as guilty. As always, for this article's sources, more articles, or to get a copy of the book, visit weepingdragon.com.